How's it going, everybody? So as some of you may know and some of you may not know, as of this morning, April 2nd, 2020, the Ninth Circuit heard oral arguments on the Duncan v. Becerra case. This video is going to be heavily dedicated to what actually occurred at oral arguments today. If you missed the oral arguments and you'd like to go and watch this for yourself, I put a link down in the description, and it is a playback of what happened at oral arguments. So for a quick summary, the Freedom Week 1 case, or the Duncan v. Becerra case, is the case that allowed for a 1-week period the importation, manufacture of large capacity magazines as they are defined in California. And for this 1-week period, individuals in California bought a ton of large capacity magazines, or standard capacity magazines as other people in other states call them. And it was only for a 1-week period because then a stay was sought by the Attorney General's office, Attorney General Becerra's office, and the stay was granted. And the stay was granted pending an appeal to the Ninth Circuit. So now we find ourselves in the Ninth Circuit on this same issue of whether the statutory language putting restrictions on large capacity magazines or magazines that hold more than 10 rounds is a violation of the Second Amendment. This case was heard in front of a 3-judge panel. The makeup of the panel was Judge Consuelo Callahan, who was appointed by Bush, Judge Kenneth Lee, who was a recent appointee of Trump in 2018. And then there was another judge, Chief Judge Barbara Lynn, and she is kind of the wild card. She is the individual who was appointed by Clinton, but she is also a chief judge sitting in the Northern District of Texas. So my quick impression of after hearing the oral arguments of these 3 judges, I think they were more educated than I thought they were going to be on specific firearms and firearms issues. And Judge Lynn, although being a Clinton appointee, I thought she was a little bit more middle ground, and I actually expected her to have a little bit more pushback on plaintiff's counsel, but it seemed to be that she was a little bit more middle ground, and that could have been because she actually sits in Texas. And as far as my general takeaways of some of the other judges, Judge Callahan and Judge Lynn, I think they also were more educated on firearms and Second Amendment issues than I thought, and they actually asked some very pressing questions of defense counsel of Becerra's office. They asked some very hard questions and pushed the defense counsel on some of these issues very heavily. So I went ahead and compiled 4 main topics that I kept seeing arise, and I'll also go through some of the general questions that were brought up during the oral arguments. But some of the main topics that I kept seeing come up with the judges' questions was the first being the type of scrutiny that should be applied in this specific case. But a lot of the questions surrounding scrutiny that were asked by the judges focused heavily on if intermediate scrutiny is applied, like the Becerra's office, like the AG's office wanted, what exactly does that intermediate scrutiny look like? And this is primarily because the Ninth Circuit has kind of a hodgepodge and varying rulings on what actually intermediate scrutiny looks like. And so the judges frequently are pressing both plaintiff and defense counsels on what exactly intermediate scrutiny should look like here in their ruling if they decide to rule that way. The second main issue that I saw come up a lot, both to plaintiff's counsel and defense counsel, was this issue of what type of deference should be given to the lower court's ruling and what type of deference should be given to Judge Benitez. And so what deference is essentially just what type of credit should they give the lower court and what type of credit should they give to the evidence and facts and arguments laid out before the lower courts. And this is primarily focused on, since it's before the Ninth Circuit has the ability to look at the case de novo. And what de novo is it's through new eyes, a completely new look at this specific case. But what the Ninth Circuit judges here seem to be questioning a lot about is, does this mean that they give no credit at all to what the lower court judge says or the facts and evidence issued in the lower court? According to defense counsel in the AG's office, essentially there should be no credit to the lower court at all, not to any of the evidence or facts or ruling. But plaintiff's counsel actually said that is not the case. Although it is de novo, it is a de novo ruling of the legal issue, but that does not mean that the court cannot look at what happened in the lower court. The third main issue that seemed to come up a lot was the issue of the takings clause. Under the Constitution, if the government is going to take a piece of property from you, there must be just compensation for that piece of property. And so under the current statutory language, what is actually permitted is the state of California is allowed to take possession of your large capacity magazines or your grandfathered magazines without any express compensation. And the fourth major issue that I saw come up a lot was in regards to the capacity limit. All 3 judges asked specific questions of both plaintiff's counsel and defense counsel about what exactly should the limit be and how far should there be a limit, or how far should the grant of limit be. So an example of this is what happened in opening arguments. The defense counsel, the AG's office, actually brought up this issue of limiting the 10-round capacity and how it's an alternative. And Judge Callahan asked a specific question about why did the state pick the arbitrary number of 10 rounds? The judge goes on to say, well, next time, why wouldn't it just be a lower amount? So the evidence in the lower court actually showed that in a self-defense situation, an individual uses an average of 2.7 rounds. And so the judge says, well, why then wouldn't the state go ahead and pick another arbitrary number and limit it to, let's say, 3 rounds, or in some way try to limit it to the 2.7? What prevents the state from lowering the arbitrary number? At what point does it become a burden on the Second Amendment? They state obviously 0 would be too much, but then where else? Is it 1 round? Is it 2 round, 3, 4, 5? Where below 10 would the limit be a burden on the Constitution? In response to the defense counsel really doesn't give an answer. He kind of wavers and goes back and forth and states, well, obviously 0 is too low, but then doesn't give a specific answer to this. In the alternative, when it is time for plaintiff's counsel to do their oral arguments and their opening statements, the judges again question this issue of capacity, and the question specifically comes from Judge Lynn, the individual from Texas. And the judge asks, would you concede that the capacity or limit of 100 rounds in a magazine is not needed, or you could limit 100 round magazines? And I think plaintiff's counsel does a really good job addressing this and gives a more firm answer than what we saw the defense counsel give. How plaintiff's counsel actually responds to this is she states that the decision should be left up to how we have been directed by the Supreme Court in Heller. And the test really is the capacity or the limit something that is typically possessed by law-abiding citizens? That is the test in Heller. So if a magazine with a specific capacity is lawfully and frequently used and in possession of law-abiding citizens, then the restriction on that specific capacity is not granted under the Second Amendment. Based on my viewing of the oral arguments, what I would actually say is I think defense counsel got hammered with more questions by the judges than actually plaintiff's counsel did. And right off the get-go, we had Judge Lee ask the question of, well, large capacity magazines, or large capacity magazines as they're defined in California, make up more than half of the magazines lawfully possessed and used in the entire nation. How then could the state of California restrict the possession of these magazines and when they are commonly used across the nation and make up a large portion of the magazines used in the nation? And then he specifically goes to state that specific firearms like a Glock 17 and like a Beretta, so here we're seeing that some of these judges actually have some knowledge of firearms. He states that these type of firearms use magazines which would be defined as large capacity magazines in the state of California. In response to this, what actually the AG's office said is, well, there is simply an alternative magazine option here in the state of California. The 10-round rule is not an actual ban on the possession of magazines, but instead is an alternative to the large capacity magazines. But in response to this, Judge Lee shuts down the argument real quick, or the response real quick, by saying, didn't Heller essentially get rid of this alternative language that you're using? In response to this, it doesn't seem like there's a big retort to this alternative option that was shut down in Heller. Instead, the representative of the AG's office just goes and gives his interpretation of what he thought Heller says. Judge Callahan then asks a question of the AG's counsel and brings up the issue, well, wouldn't it be better for someone in a self-defense situation or someone in their home to have more capacity or more rounds to defend themselves? And then in response to this, the representative of the AG's office states that on average, based on the evidence in the lower court, you would only need 2.7 rounds. And then they get into that discussion that I referenced earlier about, well, why then did you pick the arbitrary number of 10? What would then limit you from going lower and lower up to the 2.7? Or where is this threshold of when the limitation would burden the Second Amendment? And then Judge Callahan asks an issue about this deference that came up, of what type of deference should be given to the lower court and to Judge Bonita's ruling. So I think this is actually interesting. Here, the AG's office wanted to say this is expressly a de novo rule case. The Ninth Circuit does not have to rely on anything that happened in the lower court. They get to look at this new facts, new evidence, and decide it purely on their own. Actually, what we see play out is it seems Judge Callahan and maybe even Judge Lynn don't like this interpretation of the AG's office. They seem to think that is nonsensical, that they can't look at or use the lower court's ruling, rationales, evidence to make their decision. And they actually asked later in the rebuttal if the AG's office would like to backstep their previous statement of saying that, there is no reliance on anything that happened in the lower court. And then one of the closing questions, Judge Callahan mentions, well, I have a 6 Sauer. And so Judge Callahan asks, well, if I purchased, this 6 Sauer here, and it came with a large capacity magazine standard with it, wouldn't my possession of this magazine that came standard with this firearm cause me to violate this language here that you are saying does not violate the Second Amendment? In response to this, the AG's office says, well, what we would require you to do is either modify it to meet the requirements of being 10 or less rounds, or we would require you to hand it over. And so this is kind of what she's trying to do, is figure out what exactly his takings issue is, because he is saying that the statute does not require a takings, but she is saying, well, I get this magazine that comes standard with this firearm. How would it not be a takings if you are requiring me to actually give up possession of it or modify it? And so plaintiff's counsel actually addresses this in her argument, saying that in their eyes, this is a takings, whether you are requiring it to be modified or you're requiring it to be handed over to the local agencies, that would be a takings. So now let's turn to the plaintiff's oral arguments. And so one of the first questions asked by, I believe it was Judge Callahan, is what type of interpretation or what type of influence or decisions or precedent is the Ninth Circuit panel here tied to? Judge Callahan pretty much is saying, well, there's a lot of negative Ninth Circuit decisions against the Second Amendment. Are we tied to those specific rulings? And I think plaintiff's counsel did a good job here saying that the FIOC was an abuse of discretion case. Although defense counsel is relying heavily on FIOC, it does not apply here. It can be distinguished. Actually, the stare decisis precedent that you should rely on here is not the mixed interpretations of the Ninth Circuit, but it should actually be the guidance that has been laid out by the Supreme Court in cases like Heller. That is the type of interpretation that your hands are tied to. Then real quick, Judge Callahan asks, well, do you concede that the state here has a compelling interest? And plaintiff's counsel concedes that yes, obviously the state can argue they have a compelling interest of saving lives, stopping mass shootings, stuff like that. That is a compelling interest. But the question is not really if there's a compelling interest. What the issue really is the means used to address that compelling interest, and whether the means being used is appropriately tailored without burdening the fundamental right or the right to keep and bear arms. That is the real question here. It's not whether there's a compelling interest, it is the means in which the state used to address that compelling interest. Then we see Judge Callahan bring up this issue of intermediate scrutiny again, saying if this court decides to apply intermediate scrutiny, what exactly does that look like? And so plaintiff's counsel says, well, it would look like what the Supreme Court tells you it should look like. And the test is whether the statute is narrowly tailored to further a significant government interest. That is the standard issued by the Supreme Court. So then the two parties closed out. Plaintiff's counsel primarily closed by talking about the takings issue, saying that in their eyes, they believe this to be a takings. The AG's representative closed out, and almost right away, he was hammered with questions again by the judges. Then, interesting enough, Judge Lee finishes off the questioning and the closing by saying that California is a large state, there are varying localities, and there are even rural areas in the state of California. He asked essentially, wouldn't the large capacity magazine limit burden these people more? And the AG's office says no, that because these individuals can use more than one magazine, they can have as many 10-round magazines as they want. But then Judge Lee goes out and asks him again. He said, well, would your interpretation change, or would your rebuttal change if there was a limit in the state of California where you could only have 2 rounds per magazine? So essentially the AG's office said you can have as many 2-round magazines as you want. You could have 10 leading to 20 rounds. You would just have to reload. So my general takeaways after watching the oral arguments a couple times now is I think this could lead to a positive ruling in our favor. I think it is likely that they may affirm Judge Benitez's ruling. There is this takings issue that kept coming up, but I think it is likely that they may affirm. And I think I feel a little bit more confident now after hearing them ask their questions and hearing the oral arguments that this specific panel may rule in favor of affirming Judge Benitez's ruling, but we really don't know. It's probably going to be months before we get any specific ruling. If you found this video helpful and you like my content in general, the best way to support the channel is to join my Patreon. I'll put links down in the description below to my Patreon page. Another way you can support the channel is by using the various affiliate links down below. Thank you to all my subscribers and my viewers. I greatly appreciate your guys' continued support. So as always, thanks you guys for watching. Don't forget to like and subscribe. And never forget, a nation that draws a great distinction between its scholars and its warriors, while its laws are run by cowards and its wars fought by fools.